In New York, some agreement between the Manhattan District Attorney and attorneys for former President Trump, prosecutors in Trump's business records case, say a gag order should no longer bar him from talking about trial witnesses. The order barred Trump from discussing witnesses, jurors, and court staff, that is, if the statements were perceived as interfering with the case. Prosecutors say the risk is lower now after the verdict. Prosecutors are urging the courts to keep other restrictions, including protections for jurors and officials, due to heightened security concerns. Many of the 22 trial witnesses played small roles, and several were current or former employees of the Trump Organization. But a few witnesses at the center of the case gave multi-day testimonies, like ex-lawyer Michael Cohen and adult film actress Stormy Daniels. For more on the recent flurry of hearings in Trump's classified documents case, we're joined by trial attorney Jeremy Rosenthal. He's a founding partner of Rosenthal, Calabas, and Tarian. Great to have you back, Jeremy. What were Trump's lawyers arguing about the legality of special counsel Jack Smith's appointment?
Trump's lawyers are making a pretty novel argument here. They are attacking the basis of the appointment of Jack Smith, saying that Jack Smith needs to be approved by the Senate, that he is a de facto person working for Merrick Garland, who is really at the helm of this, which sort of flies in the face of the whole purpose of the special prosecutor. The special prosecutor is supposing to be really independent. I think most folks watching this kind of equate this to when you're defending a case. This is what you do. You throw every shopping cart, you turn over every fruit stand, you climb over, you run and jump over every fence to try to defend a case. I think most people would tell you that this argument is a bit of a reach, but Judge Cannon is taking it quite seriously, and she spent 3 days on the topic.
And is there any precedent for Trump's lawyers' argument here?
Not much. Special counsel has been a way of life really since Watergate, since President Nixon was called under question. And really the idea here is that the powers that be who run the Justice Department, Merrick Garland, the Attorney General, and ultimately, because the Justice Department is an arm of the executive, ultimately the President of the United States, they want a way, and they have wanted a way since the Nixon years, to basically detach themselves politically from a prosecution, saying, look, we're not the ones behind this. We're not making the decisions. The special prosecutor can pursue charges or not pursue charges, and that's on their own. So I would think that if Judge Cannon grants relief here, I would think that the 11th Circuit, a very conservative circuit, who has also rebuked Judge Cannon in this case for prior rulings, I think that they would get involved pretty quickly. I would be surprised if Jack Smith is excluded. And if he is by Judge Cannon, I would be very surprised to see that stand.
Okay, now Trump's team is saying Smith's appointment is unconstitutional because it was not approved by the Senate. Can you say a bit about that?
That goes into the inner machinations of the Justice Department, how they're formed, and how they're essentially an arm of the executive. They characterized it as a shadow government, and even Judge Cannon said, well, what do you mean by that? To Trump's lawyers, and I don't think that they necessarily had a clear answer. I think what they were trying to allude to was basically, okay, so you've put Jack Smith in place here. They asked a question which caught the government's lawyers off guard, which was, what have you guys been talking about with Merrick Garland, with the Attorney General? To which they were not prepared to answer that, and they were kind of caught a little off guard. My guess is that today or tomorrow, if this hearing continues, they would hopefully have a more clear answer to that. But trying to attack the underpinnings and the statutory framework, that is really difficult to do, and there's not a lot of precedent for it.
Yeah, so you're saying it's not likely that this ruling would play out in Trump's favor?
It may in the short term, but I doubt it would for the long haul. Really, if you're trying to deconstruct the whole way that we appoint special prosecutors and special counsels, that's really going to have a lot of long-reaching effects. If you're going to make it a political process and say that, look, the U.S. Senate needs to appoint any or approve of essentially any independent prosecutor like they would the attorney general, who is a cabinet member, then you're essentially ending the practice of the special prosecutor altogether, and that in turn essentially means that there's really not an effective check and balance against the executive branch from some type of prosecution. Remember that that again, what Trump is potentially hoping for here is one of two things. To get Jack Smith excluded would mean that Mr. Trump gets a different special prosecutor who may see it more favorably than Jack Smith doesn't want to prosecute, or that Donald Trump himself is the head of if he wins this election, can appoint his own attorney general who could effectively kill this prosecution after he is, if he is elected president of the United States. So that's kind of the end game here. And look, again, when you're defending a case, you don't do it politely and you don't ask for permission to do things that delay and can potentially win it for your client. Again, legally a long shot, but a lot of strategic advantages to it. And the primary one is that it's causing a delay, almost certainly going to be after the election, which I think was their primary goal, and that's been achieved.
Okay, and there's another hearing in the classified documents case today about a potential Trump gag order. What are the two sides saying about this?
I think what you're going to see are similar arguments in New York State. Anytime you are engaging in prior restraint, not allowing people to speak freely before they speak, you've got a really, really high mountain to climb on that under the First Amendment. And in New York State, the argument was, well, we've got to protect these witnesses. We've got to protect the process, right? The judge in that case, Judge Marchand, was essentially arguing, look, or essentially ruling that we don't want these witnesses to feel intimidated. We want the truth. We want the process to be protected. Now that that case is over, that is far less pressing, obviously, right? In this case, I don't know that that's what Judge Cannon is necessarily going towards. I think it's more geared towards the nature of the classified documents and the inability to reveal those publicly. So it really is a very fine tightrope, because in New York State, we were talking about protecting the integrity of the legal process. Here, we're talking about protecting national security. So Judge Cannon, I do think, will probably put some limitations on what can be said about that, but she may be more inclined to allow Mr. Trump and his team to publicly talk about witnesses, which was not really allowed in the New York case.
Okay, all right. Trial attorney Jeremy Rosenthal, thank you again so much for your time. Great to have you back on the show.
Always. Thank you.